Good evening, everyone. Thank you so much for tuning in tonight. We've got so much to look forward to on our fourth webinar, which is our final one in the series. And you are probably used to seeing Laura's face on here during these sessions, who's done an amazing job at organising and planning these webinars. But unfortunately, she cannot make it tonight, so I'll be filling in for her. And for those of you who don't know me, so I'm Nikki and I'm the Adult Services Officer, and I've been working on the Adults Project for about 3 years now. So we've got, as I said, we've got a really exciting session planned for you tonight where we are joined with our lovely guest speaker, Amanda, and our lovely host, Sav as well, who will be discussing everything you need to know about rights at work, bullying and harassment. And this webinar is proudly hosted by the Cleft Lip and Palate Association and funded by the VTCT Foundation. Please do ask questions throughout the webinar, and if there's something you'd like to know at the end, we'll make sure to ask it as well. If you already submitted your question via our form, then thank you so much for giving us your questions. Yeah, as I said, we'll make some time at the end to ask them. So sit back, everyone. I hope you've got a cuppa and you're all comfortable, and I will leave it to our lovely hosts.
All right, well, thank you so much, Nikki. Lovely to meet you. As everyone knows, hopefully, if you haven't seen me before, my name is Sav. I was born with a bilateral cleft lip palate. I would say at the end of my journey with cleft, but there's always ongoing underlying issues. But today we are here to talk about the workplace and rights at work. As you can see on the screen, the information for this webinar has been taken from the following source, our friends at Changing Faces. Now, if you know Changing Faces, you will know that they are a brilliant resource for backing change and, of course, support for anybody with really any differences in terms of their faith. ACAS, I don't know if I'm saying that in the right way, citizens' advice as well. So our sessions so far have looked at the following topics: CV writing, applying for jobs, application forms, and interviews. Your first day, what to expect and how to prepare. Today, we're going to talk about your rights at work, and we're going to move on into medical appointments and ongoing treatment. Now, when you're living with a cleft, of course, it is almost mandatory to go to appointments throughout your life. And today we'll be talking mainly about how to actually ask for time off for that. So we'll first be talking about the time off and medical appointments and treatment. Your employer may give you time off for medical appointments, but they are not legally obliged to do so. Unless your contract states otherwise, your employer may insist you take such appointments outside of work hours as holiday leave or make the time up at a later date. If you're disabled and your employer won't let you take time off for a medical appointment connected with your disability, then they could be discriminating against you. You can check if your problem at work is discrimination. Cleft and disability is complicated, and this will be brought up further on in the webinar. Now, do medical appointments and surgeries count as sick leave? That's definitely something that I have always wondered actually in the past, and lately, especially with a few issues with my hearing, I've been having to have a few more appointments than usual. So medical appointments and elective surgeries that are pre-arranged can only be covered by sick leave if an employee is not able to work because of a personal illness or injury. Therefore, any treatment that you have that means you are unable to work for a period of time, following that will be covered by sick leave, or it should be really legally covered by sick leave. Now, can an employer ask for a proof of doctor's appointment? The answer is yes. An employer can ask for a doctor's report about their employee's health if it is needed to stick to the law. For example, assess where the employee is to fit, if the employee fit to carry out their work, prevent health and safety risks and maybe any ongoing struggles with your work related to your own treatment. I'm going to hand over on that note to Amanda for ongoing treatment.
Thanks very much, Steph. Hi, everyone. I'm really pleased to be here this evening. My name is Amanda Bates. Like Steph, I was born with a bilateral cleft lip and palate, and I've been involved with CAPA for some years. In my day job, I work in health research and I'm a chartered psychologist. So, over to ongoing treatment. So, as I'm sure many of you will be very familiar with, it can be very difficult to juggle work and medical appointments, particularly if you are having ongoing treatment for your cleft. And you may well need help with work or particular support once you come back after a period of leave. So that might involve reduced hours or, for example, lighter duties whilst you're going through medical treatment or convalescing. So one way I've managed things in the past following surgery is that I chat with occupational health, who are typically very supportive, and I've returned to work but on what they call a phased return. So just starting off quite low number of hours and then just increasing slowly till you're back up to where you were at the beginning. So it is important to liaise with either HR or occupational health, and it depends upon how your work is structured and set up. If you are part of a small organisation, do speak to your manager about what we call reasonable adjustments. So this comes under the Equality Act 2010, and it means that employers are required to make reasonable adjustments to make sure employees with disabilities and physical or mental health conditions are not disadvantaged when undertaking their work. This applies to all workers, so that's trainees, apprentices, contract workers, and business partners as well. Your GP is also an excellent port of call. They can write you a fit note with details of any adjustments which are required. And yeah, as I said, you might be asked to attend an occupational health appointment as well. So just wanted to say something about practical tips when you're asking for time off for appointments, because these things can feel a bit awkward, and I really understand that. So what can be really helpful, break it down. So explain about your cleft to your manager when you first start work, and talk about if you do have any planned treatment and a rough timescale, if of course you know that. Obviously, try and set up a quiet time to approach your line manager where you know you're not going to be interrupted. Give as much notice of your appointment as you can. You know, sometimes that isn't always possible, but where possible, do give that. And go to them with a solution. How might you be able to make up the hours for an appointment? And Stav, I think you had some insights here as well.
Yeah, so I always try to give as much advance really as possible when I do have an appointment. And if I do say it, let's say at least a month out, then I've got the proof, I've got the, usually the appointment letter. I know things have changed when they go online now, but at least that way you have the proof, and you should be able to take that to your line manager, and they should really be able to allow you to go. In my own experiences, especially with hearing loss at the moment, I have had to rearrange appointments. So obviously dates have also been a bit more difficult to find due to COVID. So I agree with trying to find a quiet time to approach your line manager. But a lot of the time they're very well, hopefully accepting of that, and you're not really doing this every week. Appointments are usually quite far apart from each other, so it shouldn't be too much of an issue moving forward, I would say. How about you, Amanda?
Yeah, absolutely, exactly the same. I've never really had any problems at all. I know that my managers have always appreciated it if I've said, right, okay, this is the time off, but this is when I'm going to make it up, or this is how I'm going to mitigate this. And again, you're going with a solution. But in my experience, they want to know what's going on. They want to check that you're okay and that you have the support that you need as well.
Agreed. All right, so I wanted to move on to, if I can find the fit notes. I guess, I'm not sure if the slides are a little bit muddled here, but I'm sure I will find it somewhere. Okay, well, I think I'm just gonna go from here. So Okay, so footnotes. There have been a temporary change to footnotes due to the pandemic. So for statutory sick pay, very hard to say, where employees go off sick on or after 10 days after the 10th of December 2021. Employers can only ask employees for proof of sickness, such as a footnote, after 28 days of sickness, including non-working days. So proof of sickness cannot be requested earlier than 28 days. Footnotes do not have to be provided for departments for work and pensions benefit claims until 27th of January. This will not affect claims to benefits. These changes are to give GPs really more time to work on the coronavirus COVID booster program. And if you are concerned about your health condition, you should continue to go to your GP. Doctors issue footnotes to people to provide evidence of the advice that they have given about their fitness for work. They record details of the functional effects of their patient's condition, and so the patient and their employer can always consider ways to help them to return to work gradually. If you're a patient or an employee, there is more important information about taking sick leave on the government website. But over to Amanda really to explain the side of bullying and harassment at work.
Thanks very much, Steph. Okay, so obviously this is a challenging topic, but if you feel you are being treated differently or negatively because of your appearance or indeed for any reason, you might well want to seek advice on your rights at work. You may also want to speak to an HR advisor who can support you and let you know what your options are. Another source of advice and support could be your trade union, who represent employees in your workplace, even if you are not a member. And trade unions also offer their members legal support if they need it. Now, you may have heard the term unconscious bias, and it's also known as implicit bias. And this can be one of the biggest challenges at work for people with a visible difference, because it refers to biases people do not even realize that they hold. But it can be helpful to understand how unconscious bias works and what indeed can be done about it. Some people hold an unconscious bias against people with a visible difference. Because it is unconscious, the person holding it is unaware that they have it. This means that the actions that flow from it are to some extent outside their control. And we all have unconscious biases about different things. And when we act as a result of unconscious bias, our actions happen automatically. They're triggered by our brain making quick judgments and assessments of people and situations, which are influenced by our background, cultural environment, and personal experiences. And it might mean people look or stare if they haven't met anyone with a visible difference before. However, unconscious bias is certainly not an excuse for poor behaviour. Harassment, abuse, bullying, and discrimination are still unacceptable. No one should ever experience abuse in person or online because of how they look. However, people with a visible difference often encounter appearance-related abuse and harassment. In many cases, that abuse may constitute a hate incident or even a hate crime. And I'm going to explain what these terms mean and also how you can report hate crimes and hate incidents. So the different terms such as abuse, harassment, hate incident, and hate crime can all be confusing. But if you experience a verbal, online, or physical attack because of your visible difference, it will often fall into one of these categories. Abuse is a broad category, meaning the mistreatment of someone. There are many forms of abuse, including verbal, physical, and psychological. If someone shouts offensive things at you because of your visible difference, they are verbally abusing you. Harassment is unwanted behaviour which you find offensive, intimidating, or humiliating. It includes spoken or written words, images, physical gestures, facial expressions, and jokes. If someone knowingly tells a cruel joke about visible difference in front of you, they are harassing you. Harassment because of your visible difference could be against the law. This is because the Equality Act 2010 considers harassment due to disability as unlawful discrimination. You may not identify with the term disability, but this is how you are protected under the law. Hate incidents and hate crimes apply to acts which the victim or anyone else believes were motivated by prejudice based on disability, race, religion, sexual orientation, transgender identity. If someone has harmed or abused you because you have a visible difference, then this may be legally classed as a disability hate crime or a hate incident. Again, you may not consider yourself to be disabled, and this is how your visible difference is protected under the law. It's worth remembering that disability is currently defined very broadly in hate crime as any physical or mental impairment, differing from the definition used in the Equality Act. Now I'm going to come on to hate crime. So a hate crime doesn't have to involve physical violence. A hate crime could be harassment, verbal abuse, offensive or threatening texts, or trolling on social media, intimidation. Harassment is where someone creates an atmosphere that makes you feel uncomfortable. This could be because you feel offended, intimidated, or humiliated. If you're being bullied, your situation might also be harassment under the Equality Act 2010. If it is, you can take action under that law. If the bullying isn't harassment under the Equality Act, you might be able to deal with the problem another way. It might be harassment if someone has verbally abused you, asked very personal questions, for example, about your disability or religion, put up posters that make you feel uncomfortable, made rude physical gestures or facial expressions towards you, told you jokes of a sexual nature, made comments you find offensive, for example, on social media. If your colleagues say the behaviour was just friendly banter, it might still be harassment if it meets the definition of harassment in the Equality Act. If the harassment is very serious, it might also be a crime. For example, it's a crime if someone has sexually assaulted you or made physical threats. Please contact the police if you are worried about your safety. So we're thinking about what's harassment under discrimination law. So for all types of harassment, the behaviour you're complaining about has to be something you didn't want. The law calls this unwanted conduct. You also always need to show that the person who harassed you meant to make you feel a certain way, or that you felt that way even though it wasn't their intention. This is called purpose or effect. If the person didn't mean to make you feel this way, it also has to be reasonable that you felt that way. You need to show that the purpose or effect of the conduct was that it violated your dignity or created an environment that humiliates you, offends you, intimidates you, is hostile, is degrading. You also have to show that your situation is covered by one of the 3 types of harassment in discrimination law. The first type is where the unwanted conduct is related to a relevant protected characteristic like sex or race. The second type is where the unwanted conduct is of a sexual nature. The third type is where you're treated worse because of rejecting or submitting to unwanted sexual behaviour or behaviour related to gender reassignment or sex. This is called being treated less favourably. It doesn't matter if the behaviour is directed at you or not. For example, if you overhear your colleagues making racist jokes or comments to each other. Harassment is covered by Section 26 of the Equality Act 2010. Do check if your employer is responsible for the harassment. You can only take legal action about harassment if you are a worker protected by the Equality Act 2010. You don't have to have a written contract for your employer to be responsible for discrimination against you. You're covered by the law if you're an employee, an apprentice, working under an agreement with them that you'll personally do work and they'll pay you for it, a former employee. This includes casual and 0 hours workers and some self-employed people and freelancers. There are extra rules to protect people who are employed by one business but work for another, such as agency workers. If you are harassed by a colleague, so your employer is responsible for any harassment done by any of your colleagues if the discrimination happens to you at work-related events, or on business trips like an office away day, or any social events organised by them, for an example, an office Christmas party or a work-related dinner. If a colleague is harassing you, they and your employer are both responsible. The name in the law for your employer's responsibility is vicarious liability. This is covered in Section 109 and Section 110 of the Equality Act 2010. You can't usually take action against your employer if you've been discriminated against by customers or staff from other companies. However, they still have a duty to protect you from discrimination if they know it's happening. They might also be responsible if the discrimination was done by someone they gave authority to, for example, a consultant who made redundancies for them. The law calls this person an agent. If you're not sure whether your employer should have done more to protect you, you can get help from an advisor. Your employer is responsible for the discrimination even if they didn't know about it or approve of it. Your employer might be able to argue they're not responsible for the harassment by a colleague if they can show they did everything they reasonably could to prevent it happening. It is not enough for your employer to simply have an equal opportunities policy. They'll need to show they couldn't have reasonably done anything more. Okay, so back to Stav for practical tips now.
Yeah, so I'm gonna just talk through very quickly about some practical tips for managing and bullying, or any of harassment. Now, I would honestly say obtain a copy of the company policy on bullying, harassment, mainly because this way you can go to HR and you can really, state your case via some evidence from the company of what they should really be doing to protect you. When I ever start a new job, I do tend to make them aware of my past trauma and how this could essentially affect work. If it is, then I always do try my best to find someone who really is let's say in the HR department, and you can actually explain further of why you need further help. So I would say always make sure to take note of the HR team names in case you ever need to speak with them. If you need someone to speak to, Changing Faces has a helpline. We will share the details on our website, and for tips and advice about how to manage a situation when people stare or ask unwanted questions about your appearance, you can go back in our employment series to our 3rd employment webinar to find out more. Now, to move on from the harassment and bullying side, how do you raise a problem at work? Now, this can often be the most intimidating thing. If you have a problem at work, it's normally better to raise it informally with your employer first. Now, you may feel nervous about raising an issue, but employers are often open to resolving problems quickly without going through a formal procedure. Do remember, this is what managers are for, and they are really there to help keep some type of peace in the workplace. Now, for some very serious issues, an informal chat may not be the best approach. You may want to raise a formal grievance to your employer, have an informal chat with your employer first, and then you should approach your line manager as well at first. If you do not feel comfortable doing that, try and find someone else you feel comfortable talking to, such as I mentioned previously, in a manager in HR. Now, an informal chat with your employer can range from a quiet word to a more structured meeting. If you need more support, some workplaces have trained members of staff that you could speak to, for example, fair treatment ambassadors, mental health first aiders, or health and wellbeing representatives. Your workplace may have an employee assistance program, EAP, which you can also use. You might want to also talk to a trade union representative if you are, in fact, a member of a union. Now, preparing for an informal meeting, how do we do this? How do we go about this? So, if an informal meeting is set up, it's a good idea to check the ACAS website for information about your problem and how it might be dealt with. Prepare what you say. So prepare what you want to say. For example, how to explain what you're unhappy about. Think about what you'd like your employer to do and how to move forward to keep a happy workplace. You could ask someone to go with you, for example. So a work colleague, a trade union representative, an official employed by a trade union, or you can ask to bring someone else just for extra support, or for example, a translator, or just even someone that you care about at work who you feel comfortable being there for you. It's up to your employer to agree if you want to bring anyone with you. It may say in terms of your contract, so it's always a good idea to check, and that's why I always refer to a HR handbook if there is any lying around. Now, at the meeting, you can explain what the problem is and what you think should happen. Show your manager evidence if necessary. For example, your pay slips and contracts if you think that your holiday pay was wrong. Take notes if you want to remember what was said. Resolving the problem should be a two-way process. It's always a two-way process. That's what communication is about. Your manager should allow you to explain the problem. You should also listen to what they have to say. It may not always be possible to solve the problem in the way that you would like, but hopefully you can find a solution that works for the both of you in the workplace. Now, raising the issue formally, this is always a little bit tougher. Sometimes an issue cannot be resolved informally. If this is the case, then you can raise this issue formally, of course. So this is known as raising a formal grievance. If raising a formal grievance does not resolve the problem, you might be able to make a claim to an employment tribunal. This guide has also come from ACAS, where employees can go to for support. All of the helplines and all of the links will be sent to you after the webinar, if you like, or we can probably put these on screen at the very end of the webinar. So I'm going to hand you over to the law in relation to cleft with Amanda.
Thanks very much, Stav. Okay, so going to talk about the law in relation to cleft. So obviously this is quite a meaty, complex subject, and I certainly would want to give the caveat that we are not lawyers or experts in this, and we said at the beginning of this presentation, this webinar, where we've drawn our sources from. Okay, so people often ask Clapper, is having a cleft a disability? So in order to answer that, you need to look at what the law around disability states. So the law uses the term disfigurement in relation to facial difference. Now, this isn't a term that I use or Clapper use, but it is enshrined in law. So the UK Equality Act 2010 is recognised to offer more general protections than human rights legislation. So the Equality Act states, providing an individual meets the definition of disability under the UK Equality Act, they will benefit from protections afforded by the UK Equality Act and against direct and indirect discrimination or harassment in a broad range of scenarios. So first, you need to know if having a cleft meets the definition of disability. As we mentioned earlier, cleft and disability is complicated. Cleft itself isn't a disability. However, your cleft may affect you in a way that has an ongoing and substantial impact on your ability to carry out day-to-day activities, such if you have unintelligible speech. So severe disfigurement, with the exception of unremoved tattoos and piercings, is deemed to be a disability for the purposes of the UK Equality Act, which has a substantial adverse effect on the person's ability to carry out normal day-to-day activities. So does the UK Equality Act 2010 protect employees with disfigurements? Employees, including apprentices, UK employee shareholders, UK workers and self-employed individuals under a contract requiring them to perform work personally, are protected under the UK Equality Act. Employees are protected against direct discrimination, and that's where an individual is treated less favourably due to their disability, and indirect discrimination, which is where an employee has a policy, practice, or way of working which adversely impacts a disabled person. An employer does not need to know about a disability in order to indirectly discriminate. So where does a person in the UK go to register a complaint as an employee? So when making a complaint against your employer, an informal complaints procedure can also be adopted. This is likely preferable if you need a swift outcome, the discrimination is not having a huge impact at present, or you're worried about how your employer may react to a formal complaint. Make the informal complaint to somebody at work who you think can help. You may have an employee policy that tells you who to complain to. Make sure you are clear on what you want to say, have any evidence with you, and feel free to take notes. If an informal complaint is not successful, you can raise a formal grievance. Does the UK Equality Act 2010 protect job applicants with disfigurements? So the Equality Act protects against direct discrimination where individuals are treated less favourably due to their disability. This applies to both applicants and existing employees. So for example, this may arise where an employer rejects a job applicant with a severe facial disfigurement for a customer-facing role. The Equality Act also prohibits employers from questioning applicants about their health, except for certain reasons, for example, to ascertain whether any adjustments are required for an assessment process or to check if an individual is able to fulfill the requirements of a role. I'm just going to give a bit of time to considering what the three biggest gaps are in the protection offered by the UK Equality Act to those with disfigurements. So the first is, whilst those with disfigurements are protected under the UK Equality Act, no definition or explanation for what is considered a severe disfigurement is provided, and there is limited case law in this area. This lack of clarity may make it much harder for someone to prove that they should be treated as having a severe disfigurement and therefore afforded the associated protections. The second gap is that the Equality Act does not protect pure differences of appearance without physical impairment, even where these differences create disadvantages. Instead, an individual must prove that they have a severe disfigurement to benefit from protections. Many people with a visible difference will not be classified as disabled under the Act because such disfigurements may not have any adverse effect on the person's ability to carry out day-to-day activities. However, people with visible differences may still face social and professional barriers and discrimination, resulting in psychological suffering and other hardships such as poverty. The final gap, the Act does not address more subtle types of discrimination, such as colleagues making assumptions about ability or intellectual capacity of people with disfigurements, or facing general unpleasantness from strangers, such as being stared at or being the subject of unwanted comments. And just back to Stav now.
Great, okay, so for anything that we've actually discussed today, please do go to visit changingfaces.org.uk. They have a lot of information on there that we think that can really help you in terms of any discrimination that you feel that you may be facing, and they may be able to pinpoint this for you. I guess we are going to now be moving on to the Q&A. Yes.
Yeah, thank you so much to you both. Like Amanda said, it is such a meaty subject and topic, but both of you did so well. And I really, really hope that everyone listening found it really insightful and really interested to hear as well, because it has been an amazing session. Now, I do have a few questions that came in a little bit earlier before the webinar. So and also anyone who is listening, if you do have any like last minute questions that you just want to add, then please just add them in the comments box, and we'll also make sure to ask them. So if I witnessed a person that was being discriminated against by another individual, do I have a right to speak up?
Amanda, do you want to go first?
You absolutely have a right to. If you feel that you want to challenge it, you feel able to challenge it, then yes, of course, you have a right to say something. It's not always the easiest thing to do either. And sometimes we kind of have to, I think, process a bit what's happened before we might decide whether or not to take it further. But do you have a right? Absolutely.
Yeah, I would agree. I would probably say take a minute before that you do, just maybe even speak to the person who has experienced this right after, just to see if they're okay and check in, and also really to see if they wouldn't mind you saying something, because sometimes I think if we jump the gun, you know, that person might feel a little bit like, oh, you didn't ask me, you know, or I don't know. I just think sometimes asking someone straight and directly first could be a good way before jumping the boat, and you know, speaking up straight away.
Yeah, sure. Thank you both for your answers. So if I've just got another one. If I had an urgent appointment that I need to go and my manager is on leave, who would be the next best person to ask?
I would say the next person who is in charge, or whoever else that you would think really in your team that has maybe right or authority, let's say, to ask. Or if, you know, if they are on leave and you have their number, I don't think it's a problem if there's no one in the office to just let them know, and saying that we can bring this up another day. Don't worry about answering me now, just to let them know.
Yeah, absolutely. So I would just go to the person above my manager. But I would, if I was doing it on email, for example, I would copy your line manager into that email, or just let them know, somehow communicate to them that this is what's happened, this is the action you've taken.
Yeah.
And again, like we were talking about earlier, this is how I'll make up the time, or whatever, you know, again, go with that solution. But communication is the key. I try and have things in writing where I can. Not to say that, I mean, you know, people aren't there to catch you out or anything at all. It's just that people get busy, and you just if you do ever need to refer to it, yeah, look, I found it, it's on the email, etc. And again, if you do need it, a kind of evidence that, you know, why you had to step out for the day or whatever. Yeah,
I agree.
Yeah, no, I completely agree. Yeah, with both of your answers. So my last question. So if I had experienced a hate crime against me that happened a few years back, can I still report it to my employer?
I probably would say it depends on what the hate crime was and how, I mean, how severe, let's say it was. I mean, in my opinion, if it was to do with sexual health and, you know, sensitive subjects as such as that, especially, then yes, I think you should bring it up whenever you feel comfortable, because, you know, there might be a process that you need to take in just to kind of understand what's happened, and kind of just to kind of take it all in, and bring it up. Would I say that if it's small things, then I wouldn't probably bring them up in 10 years later, you know, 5 years later. But if they are quite big, like something like that, then yes, I would.
yeah, it's exactly the same actually. If it was particularly significant, and, you know, I mean, I've been aware of people where they haven't felt able to even raise something until they know they're leaving, because they're worried about the repercussions. And I wish that weren't the case, but, you know, sometimes we know these things unfortunately happen. So I think no matter how far it is down the line, if there has been something that's really impacted upon you, a good employer would want to know, so they can try to put things in place so these things don't happen again. But I think also a part of that is that you want to feel heard as well, and you want someone else to understand that experience. And I think if it's handled well and sensitively by the right people, so you need to find the right people to talk to at your employers, then it can actually be quite a positive process. Even though it's difficult, you feel like, okay, I'm letting that go, I'm leaving it with somebody else, and now I can step away, I can walk away from this.
Yeah, I totally agree.
Yeah. Well, thank you so much to you both. There's some really, really great answers. And I'd just like to say everyone listening as well that we aren't legal experts, and this webinar has been an overview based on the sources shown at the start, as well as our host's personal experiences. our lovely host, or our lovely communications officer, Kate, who's working on the background, has left some links to Changing Faces, ACAS and Citizens Advice just in the comments box. So please do take a look at them if anyone wants to know a bit more information, and yeah, listen to this webinar. So that has all we've got time for this evening. I just want to say a really, really big thank you to both of you for taking part. And I know this is not the first webinar that you took part in, and that it's been really, really amazing seeing both of you, and to all of our other lovely volunteers who have took part in the previous sessions as well. They've been really, really great. We really appreciate all your time and your presence as well, because I know it's taken up quite a few evenings. And a big thank you to everyone kind of listening at home. You can always have a look back on these sessions just on our Facebook group or our website. I think Kate will also kind of put a link into our future events that we've got coming up, and one of them is the Adults Lounge that is happening on the 19th of February, and that'll be all around self-esteem and self-confidence. So if you do want to join in the conversation, then please do sign up. Registrations are still open, and yeah, we would love to see more of you like tuning in and yeah, expressing your thoughts about that as well. So yeah, again, thank you so much to you both. I really hope you've enjoyed it.
Yeah, it's been great. It's been great. Honestly, I think if when I was, growing up, I had some kind of resource like this, it would be really helpful, particularly when you're starting out in the workplace and you have a cleft palate. It can be quite daunting, and you might not know really what to expect and what your rights are.
Yeah, I completely agree. Navigating all of this, or alongside navigating work, can feel quite challenging and quite difficult. But I yeah, as you say, if these resources have been around previously, that would have been great, but they're here now. So do refer to them, do use them, and yeah, any feedback or comments are gratefully appreciated.
Yeah, definitely. Yeah, thank you so much again to everyone listening, and hope you have an amazing evening and rest of the week. Bye.
Great. Thank you. Bye.
Thank you.